Hello, everyone. This is Mallory Flowers on behalf of Jennifer Schaus and Associates. We are coming to you live from Washington, D.C., and welcome to our Webinar Wednesday series. Our webinars are held every Wednesday in 2018 at 12 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the Webinar tab. In the interest of time, we do not take questions. Our speaker's contact info is posted on the last slide, so if you have any questions, please contact the speaker directly. The recordings are also on our website underneath the Archived Webinar tab, as well as on our YouTube channel. All right, and this is just a quick blurb about us. Jennifer Schaus and Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign, defense contractors, and civilian. Our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can be found on our website. So let's dig into today's presentation, which is commercial item contracting with Department of Defense, the new rules, and David Dempsey is our speaker today. You can learn more about his background on this slide. Thank you, David, for joining us, and I'm going to hand the floor over to you now.
Okay, thank you, Mallory. I'll go ahead and start, and we'll go right into my first slide on commercial item contracting with the DoD, these new rules, and that's the next slide on the screen, please, Mallory. You'll see this is what I'm going to be covering, and the in item 2, DeepApp is the Defense Procurement and Acquisition Policy Office in the Defense Department. The role of DCMA has expanded considerably in commercial item determinations and to a large extent also price reasonableness determinations. And then observations I'll be giving throughout, I think, for the most part. Now, going to the statutory authority on the next slide, the 3 statutes I've got there, they all have information in there regarding the treatment of commercial item contracting with DoD. But one thing I'd like to point out to you all is 2018 NDAA, which contains the Modernizing Government Technology Act, and that's going to be sections 1076 and 1078, and also highlight an OMB memo to you, which is M-18-12, which came out February 28th, 2018. And that's on the implementation of this statute. It's Modern Government Technology Act statute. And I bring it to your attention because many of the companies involved in this webinar and webinar series are IT companies. And this statute means to modernize government technology because they've found out, OMB discovered that of all the money going to federal agency IT budgets, over 60% was for maintaining legacy systems. So since they will be purchasing a lot of IT equipment, services, et cetera, over the next several years, that will be commercial products and commercial services. And I should also note, by the way, that the OMB implementation also stresses cybersecurity. Anyway, on the next slide here, I'm focusing on the 2017 NDAA, and I think this is pretty much what was implemented with respect to the rules that came out and became effective January 31 for the Defense Department. And these statutory references, you'll see in 876, there's a reference to knowledge-based service. Knowledge-based services, and no one really knows what that means. There's not much in the legislative history about it. So it's safe to presume that it's going to be IT and computer or software related services. But it may help you when you're trying to identify where you come in as a commercial service provider, that you go back to this basic statutory reference to indicate that you're a knowledge-based service. And then on slide 11 is my usual mirth when I'm doing one of these things here, because the next slide indicates that industry wanted something pretty straightforward on how to do commercial item sales, and DoD didn't want to do that. They wanted something fairly complicated. I'm sure all of you recognize the Pythagorean theorem, but the other one got out of nowhere. So we'll just move right on to the definitions, which starts on the next slide. And in there, I know it's boring to go over definitions when you're talking about new clauses, new policies and stuff, but in this case, there's a little difference here, because we have some new concepts associated with commercial item purchasing by DoD now. And also we have some initial glitches. If you see the definition I've got for 212.001 on market research, that is in the Federal Register, which announced these changes effective January 31 and effective now, or effective then. But the definition for market research, which is supposed to be in 212.001, has not been put in there yet. That got to be a glitch, and I say that because just yesterday I was checking the Air Force's website on the DFAR, and they're up to date all the time, and it's not there. So for whatever that's worth, going over the significance to you all is that market research is going to go over everything. And as I say later on, DCMA has been on this. They have a DCMA commercial item group, CIG, has been in action for over 2 years now. So they've done a lot, and this is what their market research has been doing. Because DCMA, I'll be giving you the site later on, has a similar role as DCAA in the commercial market area, or commercial market research, and they have quite an extensive amount of information. And you can see I've got the website right there for the CIG, the Commercial Item Group. But if you compare the new definition that is missing at the moment, but will sooner or later be discovered, and compare that to the FAR 2.101 definition of market research, you'll see there's a considerable gap. Now, when the definition that's in the sooner or later going to show up in the DFAR, it says at a minimum, market research includes contacting knowledgeable industry and government persons. Now, government persons means the DCMA commercial items group, as near as I can tell, after looking at several hundred pages of information on this. So contractors should take a look at what they're doing at their website in order to be able to predict how to respond to contracting officer requests for information on their commercial items. So moving along now to some other definitions on the next page, we have the definitions that these are new for the clause, the DFARS 215-7010 clause on requirements for certified cost for pricing data or other than certified cost for pricing data. And that is a big difference, because the difference that's involved here is whether or not you have to, is going to be a presumptions associated with certified versus certified data. And these conditions are pretty straightforward. The relevant sales data is something that's come up that's a bit new for being in the DFARS regulatory scheme. So when we go to the next slide, we have the definition associated with non-government sales and uncertified data. Uncertified cost data and certified cost data have legal significance because the contracting officer has a presumption of relying on the certified cost data for purposes of price negotiations. And therefore, that leads to what is essentially strict liability on a refund for the government or reduced prices. The case law, et cetera, indicating that the government relied on it, and if it wasn't true, the government gets the benefit of that misrepresentation, mistake, or whatever. I hesitate to call it a false claims act. I know people do, but I don't like to do that. So that's the difference. And of course, the FAR recently, last couple of years, defined data other than certified cost data as data that's not certified, as if that is a serious requirement for an explanation. Okay, so on the next slide, we've got we have missed the slide here. Now, one of the definitions is non-traditional defense contractor. So Mallory, can you see if you've got that in there? Because that's something I want to point out. I don't know if it was skipped too fast. It'd be one of the two prior slides. It'd be before these. Try another one and another one. There we go. The non-traditional defense contractor is defined as a company that has not performed a full coverage, CAS-covered contract or subcontract in the previous year. Definition is going to incorporate quite a few prime and subcontractors, because a traditional defense contractor is now going to be a small business, a contract which is a fixed firm price for commercial items or fixed firm price awarded on adequate price competition, or below the Truth in Negotiation Act threshold. That encompasses quite a few, but it's the way this definition is working out. I don't know if it was intentional, but virtually every small business is a non-traditional defense contractor, because they would no small businesses are exempt from full CAS coverage, and as a consequence, by definition, they're a non contractor. So the reason this definition makes sense, is significant, is because there's a presumption now attached to suppliers of products or services from small businesses, or those companies, medium size, doesn't make any difference, that have not been subject to full coverage, CAS-covered contract or subcontract within their preceding year. And all the bigs are going to be with full CAS coverage. And as an aside, full modified CAS coverage, which most companies are subjected to either as a practical matter or by choice, That's going to be cost accounting standard 401, 402 on consistency, 405 on keeping track of unallowable costs, and 406 on the consistent accounting period. The point, though, being is that most or a lot of subcontractors and many prime contractors are going to be non-traditional subcontractors and or non-traditional defense contractors, I'm sorry, and therefore they're not going to have to go through the process of a commercial item determination. Whether or not but that will not exempt you from a price reasonableness determination, because that's essentially based on another statute. Anyway, I'm glad we were able to cover that. And then go on to the next slide, Mallory, which will be where the hearts appear, the two hearts right there. Yeah. This is a change to the definition of commercial item, which was done in the 2018 NDAA and modifies the FAR. And what that does here is just added non-developmental items sold to multiple foreign governments. For years, contractors have wanted to have their supplies to foreign governments count, and that did not happen. It's now happened as of last year, or January 31st. It's now in the books. And then finally, if you have had previous sales using commercial item acquisition procedures, and this is a little tricky here because the regulation says commercial item acquisition procedures, but the focus for DCMA and contracting officer will be on the literally part by part analysis of a commercial item determination and price reasonableness of that commercial item after it's been determined to be a commercial item. So this particular area is not clear in the regulatory scheme. But right now, I would say that you're good in going to a contracting officer or your prime contractor and saying, you did this, you bought this from us using commercial item acquisition procedures, therefore the contract and the item are deemed to be a commercial item determination. So you don't have to do a lot of stuff. And a lot of stuff we'll be getting to in a minute. Now, taking aside here on the next slide to explain that the various thresholds which are relevant to contracting officers. You can see the first one, the simple acquisition threshold has been raised 100,000. It was now 250,000, and this is as of April 13th. And the micro purchase threshold is up to 5,000. And I have basic there because there's various changes in the simplified acquisition threshold and the micro purchase threshold based on other uses. For example, this would be $15,000, $25,000 if it's going to be overseas in the contingency area, that sort of thing. But the most important change, which becomes effective after July 1, is the threshold for Truth in Negotiations Act, or the requirement for certified cost or pricing data, is going from 750 to 2 million. So what this means is the contractor or the prime, if the threshold for the contract, and the have to keep in mind the FAR convention that says dollar thresholds are measured by the total value of the contract, including options, etc. If it's under $2 million, then the contract is exempt from the Truth in Negotiation Act requirement for certified cost or pricing data. And already explained what the value of that is. Okay, so now we're going to break out, starting with the next slide. We have an idea of what the new rules are supposed to do, and now we get into what the new rules are, how they're going to be implemented. Now, near the bottom of the page here, I've got the website link to DeepApp, and their commercial item guide is broken into two parts. The commercial item determination, that's the process that the government will go through to assess whether or not the item or the service being offered is a commercial item, and if it is, it goes into the Part 12 or the Part DFARS Part 212 procedures, etc. Makes things easier, satisfies the statutory preference to purchase commercial items. And then we get into the next element of the guidebook, DPAP's guidebook, which is on pricing. And this is the requirement to purchase commercial items or any item at a reasonable price. Now, what's happened is illustrated by the next slide, is that the price reasonableness determination appears to be the more relevant evaluation process than does the determination on whether or not the item is a commercial item as judged by the definition of the FAR clause. And one thing that you, as a contractor or subcontractor, that you're always going to want to do is keep the price reasonableness determination focused on a price analysis. If it's focused on a price analysis, you can avoid giving or submitting a lot of cost data, and that's what you'd like to avoid is cost data, because that's a burdensome type of process, and it can lead to essentially providing all the cost or pricing data you would if you were supplying to a missile system, whether or not you're providing something as straightforward as an IT service. So continuing with this price reasonableness determination on the next page, we have the reference to 710D, because that's got what could be construed by contracting officers as a authority for them to ask for all cost data, but just don't certify it. And what I've got there is, to some extent, verbatim from the regulation, from the clause in this case. And it indicates that the text indicates that other than certified cost data is supposed to be the minimum necessary to permit a price reasonableness determination. But what I think that means more than anything else is that when you're going to ask for other than certified cost data, then you, the contracting officer, should evaluate what is the minimum data required for the price reasonableness determination. So the difference in degree, I think, is pretty straightforward. If you were providing a product, the government could ask for material costs, labor costs, overhead, G&A costs, et cetera, and go down to the significant detail versus just getting a rough number. Same with services. They could ask for the details associated with the contractor's wrap rate for the labor hour, or however the cost is being evaluated. Service contract is usually going to be a labor hour. But the minimum necessary to permit a price reasonableness determination could be, rather than the details associated with the wrap rate, It could be the last 4, 5, or 6 wrap rates for the service being provided. So providing, in a sense, 6 items of information versus 6 explanations of your wrap rate for the last several contracts. So be sure to keep that in mind when, if it gets to a point that you have to negotiate what this provision means with a CO or with your prime contractor. Okay, and then moving on to the next, we've got the focus on the commercial item determination. And what DeepApp has done is they put a fairly significant effort into the commercial item determination. And what they have done is taken the FAR clause, which we have been familiar with for years, and gone through and identified and explained with examples elements of that FAR clause or that FAR definition of commercial item. And we all know that includes, items of a type, whether the item evolved from a commercial item supplier service, whether it's a modified item versus a COTS item. The commercial item and a COTS item, the difference there is that the COTS item is exactly with no change, without modification, as the definition says. COTS item is supplied to the government that's completely unmodified from what's supplied to a commercial purchaser, versus a commercial item can be modified. And then it goes on to these other details. And we went into non-developmental items, and that is principally for products, but sometimes it's not. And I've looked at, on the next slide, I've gone into services of a type. And there it just indicates what we already know, but it does permit not only the catalog price for trying to identify whether the services of a type comes within a commercial item determination. It also has a current market price, which is what your sales data will show, which may not be the same thing as a catalog price. And then, because of the confusion associated with what knowledge-based means, this is from the statute, there could be more as yet tests for what services need to be, what needs to be identified for services for purposes of knowledge base. Like I said, whether it doesn't mean IT, does it mean software as a service, that sort of thing. But with respect to services, we go to the next slide. We have one very critical test, and that's going to be developed at private expense. So what we've got now is the meshing of a commercial item determination, whether the physical product or the actual services is commercial or of a type, now being defined by costs or the price reasonableness to some extent, but it's being identified by by numbers. Anyway, if you develop this service at private expense, even notwithstanding the contributions from the government on a G&A allocation, you can still be a non-developmental and therefore a commercial service. And as I mentioned earlier, the reference to foreign governments is new, so I've highlighted it here again. Now we go back to pricing, which is next slide, and there you'll see that the price reasonableness determination seems to be focusing on market research, which is normally, does the product exist in the commercial market? And they're now bringing in pricing. So the price analysis is for price reasonableness determination is now, as it should be, focusing on the cost or the price for purposes of whether it's a reasonable price. But here, the government is starting to mesh, and you'll see it when you are fortunate enough to read Part B. You'll see that the items seem to be a commercial item if they like the prices. So you see my conclusion there is that there's a question about the commercial item determination itself. The price analysis may be more important than the physical analysis of the product or the analysis of the service and whether or not it exists in the commercial market. So I've got this last page, this last slide, where first of all, you've got DCMA's commercial item group. There is a DCMA Annex 213-01, revised February 2017, entitled Technical Support to Negotiations. That is to say, they're going to look into whether or not this is a commercial item or not. And when you go to their web page, you'll see they've got links to databases on products. They don't have much on services at all. And the FAQ link is pretty good, in my estimation, but there is one sentence in there, particularly states that DCMA may not consider an item to be a commercial item simply because it's on the GSA schedule. So now you've got one of the more fundamentals in procurement, where if you're on a schedule, it's a commercial item, and you go any further, and DCMA is now saying that we have the authority to, and to some extent, we have the wherewithal to determine whether or not an item on the schedule is in fact a commercial item. Anyway, that finishes up my presentation, and I think Mallory, you want to take it over now to complete.
Thank you so much, David.
Okay, and if there's any questions, just email me.
Yeah, thanks, David. Thank you for sharing your time with us today, and thank you for everybody who joined us. And like David said, if you have any questions, please feel free to contact him directly with all the information you see on your screen now. Next week, we are covering Procurement Integrity Act. What info can you have and when? And this concludes our webinar. Thank you, everybody.
Thank you. Take care.